good afternoon, everybody. Welcome to COVID-19 and Child Custody Issues. Today we're going to be presenting some useful and timely information that folks are dealing with in these challenging times, as well as taking your questions. My name is Alex Hunt, and I'm the founder and managing attorney at Hunt Law Firm. We serve clients in Katy and Cypress, Harris County, Fort Bend County, Waller County, and the entire greater Houston area. Our practice is dedicated to family law, divorce, and child custody issues. Now, before we talk about COVID-19 and child custody issues, we need you to understand that watching or participating in this video does not create an attorney-client relationship between you and the Hunt Law Firm or any of its attorneys. While we would love to represent you, watching this video does not mean that we do. Secondly, nothing in this video should be taken as legal advice. Our goal in these videos is to educate you about family issues, so we can't give legal advice until we know all the facts and circumstances of your particular case. So since we don't know all of the circumstances of your case, you should take all information presented in this video as exactly that: no cost, useful, and timely information. Okay, now that we have our legal disclaimers out of the way, if you can hear and see this video loud and clear, this is the first time we're doing this, so we want to make sure that we're doing it right and that you can hear us. Please hit the thumbs up at the bottom right of your screen so that we know that you're on board. Second, if you know a friend or a family member who needs to know about COVID-19 and child custody issues, or who might have questions about COVID-19 and child custody issues, you can share this Facebook Live with them now, and hopefully they can hop on and join as well. Finally, if you have a question or a comment about coronavirus and child custody issues, you can post it in the comment section, and we'll definitely try to get to it if time allows. So, COVID-19 has changed everyone's lives, and while we're following the county stay-at-home orders and the CDC, state, and county orders, Hunt Law Firm remains 100% operational. We're still working and serving our clients remotely. We're still available for initial consultations with clients, and we are still serving new clients for initial consultations through telephone or through video conference. For more information on how you can get in touch with us or about what we do, you can visit our website at familylawyerkaty.com. We also want you to know that the courts in Harris County, Fort Bend County, and the surrounding counties are all open and functioning, but in different ways. Many of the family courts are preparing to move their in-person hearings online through Zoom or similar video conferencing platforms. And the bottom line is, if you have an ongoing family law case, your court should be moving things along soon. And if you want to file a new family law case, the courts are open and accepting new cases. You can find a full rundown of the status of our local courts, recent emergency orders, and more at our blog, which is at familylawyerkaty.com. And on the top of the page, there's a link called blog. And you'll be able to see updated and specific information for each county and their courts. So today, I am happy to be joined by Hunt Law Firm family law attorney David C. Adams. Good afternoon, David.
Good afternoon, Alex.
All right, take it away, David.
No problem. So first thing I'd like to talk about is a standard possession order. Today is April 13th, and many of you have either heard of, or if you have a child custody order, have a standard possession order. It's sometimes called an SPO for short, and the easiest way to explain it is that it's the default order in the Texas Family Code. Parties can agree to something else, but judges usually order the standard possession order, and that's what many custody cases are governed by. The standard possession order designates which parent has possession of and access to your child and when. Typically, one party is known as the custodial parent, and the other party is known as the non-custodial parent or possessory conservator. Now, possessory conservators with a standard possession order get extended summer visitation that lasts 30 days in the summertime if they live within 100 miles of the child's primary residence. However, those dates, those 30 days, when they will occur, must be designated by the possessory conservator on or before April 1st. Now, today is April 13th. So if you're the managing conservator or the custodial parent, and you want to know when your co-parent is going to have the kids for their extended summertime and they haven't already notified you, then the answer is the month of July. Parents who don't give their notice for when they want to exercise their extended summer possession by April 1st automatically get July 1st through July 31st. If you're the custodial parent and your co-parent's extended summer is set because they've already told you when they would like it to be on or before April 1st, or they didn't tell you at all and now you know that they get the month of July, you have until Wednesday, April 15th, to give your co-parent written notice of one weekend that you'd like to have possession of the kids during their extended summertime. So, if you're a non-custodial parent or a possessory conservator, meaning that you have the kids less time than the other parent and you didn't already designate your extended summer, then get ready for quality time with your kids for the month of July. If you're the custodial parent or the managing conservator and you don't want to go 30 straight days without seeing your kids, then make sure and designate your weekend to have the kids on or before this Wednesday, April 15th. Alex?
All right, thanks, David. The second thing we'd like to discuss are possession schedules and the exchanges of children during COVID-19. So, as everyone in our area likely knows, on March 24th, Harris County Judge Lena Hidalgo and Fort Bend County Judge K.P. George both issued stay-at-home orders for all Harris County and Fort Bend County residents. Now, the question that we've received from our clients is, do I have to exchange the kids with the other parent if there's a stay-at-home order in place? There was a few hours where that question wasn't answered, but then the Supreme Court came and stepped in. The answer is yes. On March 24th, the same day that the stay-at-home the stay-at-home orders were issued, Harris County and Fort Bend County issued their orders, and the Supreme Court of Texas issued an emergency order related specifically to COVID-19 and stated that, quote, possession of and access to a child shall not be affected by any shelter-in-place order. So that means that possession and access to kids should continue as if there was no virus, there's no school closures. It should just continue as though this wasn't happening. So what can you do if you're scared to exchange your kids, you feel that they might be in danger? There's three things to consider. First, and always, communicate with the other parent in writing your concerns. And an email works great for this. If you use co-parenting software like Our Family Wizard or Talking Parents, use that. If you want to suspend visitation during the stay-at-home orders, explain the circumstances and respectfully lay out the reasons in writing. Even if you don't believe the other parent will agree, you should offer scheduled make-up time in your communication, and hopefully this approach will work. If the other parent wants their visitation during the stay-at-home orders, send that written communication encouraging them to follow appropriate health and safety procedures. Again, do this even if you think that they're not going to do it. So that way, if you ever need to go to court, you can make it clear that you've attempted to co-parent with your child's other parent. Talk with your child about proper health practices before their visit. You could ask the other parent to alert you if your child starts to feel ill. Another idea is to request that the co-parent take your child's temperature every day and let you know if they start to run a fever. Finally, if you refuse to part with your child during the stay-at-home orders, understand that you might be violating your custody order. If you feel your child's health or well-being is in true danger, you should discuss your options with a Texas licensed attorney and consider filing something with the court so that you aren't held in contempt. The courts are still operating for emergency matters, and it's worth noting that the courts are not only functioning, but they're also giving special priority to cases where a parent is denied possession or access. So your parent could bring an enforcement action against you, and you might have to part with your child and pay attorney's fees. So be very careful if that's the course of action that you're going to take. Consult with an attorney on the best actions that you can take to protect you and to protect your child. All right, over to you, David.
Thanks, Alex. So the next thing that I'd like to talk about is child support. Now, unfortunately, many people have been laid off, furloughed, or are finding it very difficult to find work right now. And a question some of my clients are asking is, how do I pay child support if I lose my job because of COVID-19? Understand, unless a court orders otherwise, you still owe the child support to the other parent. But here are some things to consider if you find yourself in the tough situation of owing child support but not having a job to pay for it. The first thing, as Alex already mentioned, communicate with your co-parent. Communicate your employment situation to your co-parent in writing. If you have proof of your employment situation, that you've been laid off, that you've been furloughed, that your pay has been reduced, then include that with the communication. Additionally, many people are going to receive government stimulus checks at some point, potentially from the federal government. Consider using those funds to pay child support when you receive it. If you haven't considered applying for unemployment, do so. Showing that you've done everything you can to find new employment or to receive benefits is very important in these situations, not only to show your co-parent, but potentially to show a judge later in court. Seek every avenue possible to pay your child support before you can get the court to lower what you owe. You can't go to jail for not paying a credit card bill, but you can if you don't pay child support. And seek out every opportunity to limit other expenses. For example, many mortgage companies are allowing deferrals of your mortgage payments. The same is true of student loans. Take advantage of those and other similar opportunities. Having said all that, nothing will stop your child support payments from coming due and accruing interest. So to avoid an enforcement hearing being brought against you, you should consult with an attorney and bring a modification as soon as possible if you find yourself in this tough and unfortunate situation. Alex.
Thanks, David. And I do want to remind folks we have one more topic that we wanted to cover today. But if you do have a question for us, you can leave it in the comments, and we're going to be answering some of those questions in just a couple minutes here. So our final topic for today, with all the health concerns that we're facing right now, many of us are not only worried about ourselves, but are worried about our family members. And one of my clients expressed to me that they were in a vulnerable, at-risk population group, and they had been in isolation for some time, and they were concerned that when their child returned home from an extended visit with their co-parent, that they could possibly have contracted coronavirus. So my client thought that their co-parent had not been practicing proper social distancing with their child. So the question was, what do you do in a situation like that? There's no 100% right answer, but consider these things. First, most custody orders contain a clause stating that you need to notify the other parent if you won't be exercising your possession of your child. So if you're in a vulnerable health population and would prefer that your co-parent maintain custody of your child while the curve is still flattening, and we're in the midst of this pandemic, express that to them in writing according to your custody order. Second, and you've heard us say this throughout this presentation, but communicate. Put your communications and your reasoning in writing. Don't just not exercise your visitation. If you have a verbal conversation, put it in writing immediately after you have that conversation. And last, if your child will be returning home to you, speak with your other co-parent to figure out if your child has been presenting any symptoms of COVID-19. Have them report their temperature. Remember, just because your child hasn't been isolated like you have doesn't mean that they have the virus, but you still have a right to try to seek some of those answers to those questions that you might have about whether they've been exposed or not. So that's all the content that we wanted to present today. So continue to submit your questions. We're going to go to the very first question that we have here, and it's from Daisy. Get it on the screen. Do you have the schedule for 2020? So I assume what you mean there, Daisy, is the standard possession order schedule. We do have that on our website. If you go to familylawyerkatie.com and then click the resources tab, you can scroll down and it will have our 2020 standard possession order calendar, which lays out when the managing conservator and when the non-custodial conservator would have overnight visits with that child. And of course, again, every family court order is going to be different. That one follows a standard possession order and should help you a little bit to understand what your particular standard possession order looks like. So the next question is for you, David, and the question was basically just about what are the courts doing county by county. Hunt Law Firm, we serve folks in Harris County, Fort Bend County, Waller County, Austin County. What in particular are the courts that we practice in? What are those courts doing in order to keep things moving?
That's a great question, Alex. And the thing I would say is the two main counties that we serve are Harris County and Fort Bend County, and they're all doing something a little bit different. Suffice to say, there are a couple of things that all the counties seem to be doing. First of all, they're all hearing in one form or fashion essential matters. Now, each of the courts and some of the counties are defining differently what essential matters are, but especially for the purposes of today's topic, one thing to keep in mind is that denial of possession and access to a child, if someone's not getting their visitation the way that they should, all courts across the board are considering that an essential matter. Another note, something that I know I've heard about on the news that's been on the rise, has been family violence. Understand that if you're in a situation where you or a child is experiencing family violence matters are continuing to be heard pretty much unfettered. So if those are an issue, then you can absolutely seek redress in the courts about those issues. The other thing I would say, too, is that both counties, Harris and Fort Bend, and the surrounding counties are making provisions, usually by agreement, to have other matters that aren't necessarily considered essential, but that the parties want to move along through the courts, either done on what's called a submission docket, where paperwork can be submitted to the court, or through a virtual hearing, such as through a Zoom conference. But the important thing to note is that all the counties and the courts are still open. They're still hearing matters. And I know my personal practice that most of my clients' issues are still being addressed and met by the courts at this time. Alex?
Thanks, David. The next question we have here is from Kim, and she asks, how old does a child have to be to say they don't want to see the other parent anymore? And that's a really good question. That's a common question that we get a lot, so you're not alone in that, Kim. But, so the child saying that they don't want to be with, see the other parent or have any visits with them is not something that would be binding on the court by itself. So if you have an ongoing case, or if you bring an ongoing child custody case, then the court would you or your attorney would be able to file a motion to confer with the child. And if the child is under 12 years old, the court has discretion about whether they're going to interview the child in chambers. When they interview the child in chambers, it's going to be on the record. There's going to be a court reporter that's going to be taking it down. Whether the court reporter's record is going to be accessible to the parents is something that the judge would decide. But overall, the judge doesn't have to grant an in-chambers interview for a child that's under 12. If the child is 12 or over, the judge has to interview the child. Now, what the content of that would be, where it would be, how long it would be, what types of questions the judge would ask, that's entirely up to the court. And even if your child says, absolutely, positively, I don't want to see my child anymore, or my parent anymore, it's 100% up to the court, or if you're doing a jury trial, it would be up to the jury whether the child is still going to be visiting with their parents. It doesn't take any of the responsibility away from the judge in order to make the determination of whether visiting with a parent would be in the child's best interest, but it's just another piece of evidence that the judge can and should consider. So thanks very, very much for the question, Kim. All right, David, we've got one more question here for you. The question is, my son is a senior in high school and was supposed to graduate in May, and if he doesn't graduate because of COVID-19, do I still have to pay child support? This is a really timely question because we don't know when kids are going back to school. We don't know the way grading is going to work and graduation is going to work. So what do you say, David?
Thanks, Alex. The first thing I would say is just everybody be clear. There's a difference between technically graduating and going to a graduation ceremony. I would imagine there are going to be a lot of schools and a lot of school districts who are going to come up with a plan probably fairly soon, although it's still April, so they've got some time, but probably sometime by May for what they're going to do, especially about seniors who are on track to graduate at the end of this year. Understand, even if they don't have graduation ceremonies, that doesn't mean that your child may or may not be graduating. So that's one important distinction. The second thing that I would say is keep in mind, most likely the standard language in a custody order regarding child support is that you're obligated to pay child support until that child reaches 18 years of age or graduates high school. So for whatever reason, if your child was on track to graduate this spring, COVID-19 or not, they do in fact not graduate, and that's the language in your order, you are going to be obligated for that child support until that child does graduate. Alex?
So still a lot of questions there. We're still waiting on school districts to figure out what they're going to do with our high school senior and all of our kids' grades and what graduation is going to look like and whether our kids are going to have to go to school during the summer. We just don't have those answers yet, but I imagine we probably will be having them pretty shortly within the next few weeks. So that's all we have for you today. Thanks very much for joining us, and thanks for watching COVID-19 and Child Custody Issues, brought to you by the Hunt Law Firm. If you did find this video helpful, please hit the like button. If you thought of somebody who could use this information, please share it with them. And remember that we'll be back later this week and again next week. This week, we're going to bring you a Facebook Live touching on some of the financial issues in family law cases created by COVID-19 and what folks should do. If you need legal representation on a family law matter, you can visit our webpage, familylawyerkatie.com. That's familylawyerkatie.com. And make sure to follow us on Facebook. My name is Alex Hunt. I'm thanking you, David Adams, and I hope you have a great day.